Good morning, everyone. This is Lisa Lieben with IRMA. We'd like to welcome you to the second part of our month-long virtual education summit. Today, we are going to be discussing internal investigations, what you should know. Our moderator today is Susan Garvey, Director of Legal Services with IRMA. We also have a member panel of Eric Gunther, Village Administrator from the Village of Mundelein, Carrie Lewandowski, the Public Safety Director for the Village of Glencoe, and Tom Friel, the Assistant to Village Manager for the Village of Morton Grove. Just a couple of housekeeping items. If at any moment during the presentation you have a question, feel free to use the Q&A section located at the bottom of your screen. If you click on that, you can type in your question that you have for any of our member panelists today. We will read them while we are going through the presentation so that they can answer anything that you may have. If the questions do tend to get a little lengthy, we will hold off till the end of the webinar. Otherwise, we'd like to answer your questions in the time that you are asking them. With that, I will turn it over to Susan Garvey to start the presentation.
Great, thanks, Lisa. Good morning. As this indicates, we're going to talk about internal investigations. Today, I want to thank our member panel for taking the time to help us out. They have all had fairly recent internal investigations that they've completed, so I've asked them to kind of help us out. They can share their experiences in different areas of things that they've done, things that they feel are successful. So hopefully it will be a very good learning experience. So here's our agenda for the day, or morning as it is. So we want first to, what is the objective of an internal investigation? And when is that investigation triggered? How do you conduct that investigation? There's some legal considerations, when we're talking about interviewing or conducting that investigation. And then we want to talk about executing the results of the investigation. So to start off with the objective. So here's the objective. Okay, we want to make sure that we're gathering relevant facts. We want to make a determination as to what happened and what the possible consequences should be. Doing a fair and impartial objective investigation is really kind of the best way to address these objectives. I mean, we want to mitigate a problem. We want to make sure that an internal problem doesn't blow up and become something much bigger. We want to try to prevent legal liability. Maybe situations where these investigations are going to actually show that there is some legal liability, but that's not a reason to not do that investigation. We can address that as that goes along. So this is really the objective of what we want to get to when we are doing internal investigations. All right, so when we're talking about when to conduct an investigation, I have a couple of initial thoughts. And the first is that not all issues that may be raised by an employee will require the initiation of a full-scale investigation. It may be something that could lend itself just to like an informal resolution. Maybe there's just a misunderstanding in the personnel policy, or maybe the employee just received misinformation, and that can be corrected by, either giving them the proper provision of the personnel policy or correcting that misinformation. You may also consider that you may save yourself some internal investigations by doing really thorough background checks and reference checks. So generally, you're going to find that good people don't turn bad, and it also may help with an investigation into like a negligent hiring claim. So that's just, like I said, some initial thoughts. But if you aren't sure whether or not something should trigger an investigation, I always say it's better safe than sorry. And if you think that an investigation is warranted, you should go ahead and initiate that investigation. So what initiates an investigation? A complaint or a grievance. Somebody makes a complaint, somebody makes a grievance, that should trigger an investigation. Don't fall into the pitfall of this isn't really a complaint. If an employee comes to you and says, I'm having trouble with, Joe, he's making inappropriate comments, but I'm not really making a complaint. I just want you to know about it. Don't fall into that trap. somebody comes to you and makes that complaint or makes a statement like that, you have to initiate the investigation. And your comment to that employee should be, you've made a complaint and now I need to do an investigation. So again, that's a pitfall that I think some employers fall into, and I encourage you not to do that. So there's no specific criteria under the law for the filing of a complaint, but your policies and procedures should have some criteria set forth. You always want to make sure that you are following your policies and procedures. If you're noticing a suspicion of any kind of misconduct, you may want to, if it's, what do they say, if it quacks like a duck and it looks like a duck, it's probably a duck. So if you're seeing a suspicion, you have a concern, I think that it's an appropriate trigger for an investigation. There doesn't have to be a formal allegation of a policy violation. If there's a possibility that a policy could be violated, or maybe you know or should have known about the violation, so it's conduct that is so open that you can see that there is a potential violation. Like I said, it doesn't have to be a formal complaint. If you're seeing something that is a potential violation of your policies, then you should be initiating an investigation. Unexplained changes in an employee's behavior or their productivity, might be looking at maybe some workplace drug issues. So again, these are the things you may be noticing, and if they're open and obvious, then you need to really be kind of paying attention and determining whether or not that needs to initiate an investigation. Clearly, if you get a lawsuit or a threatened lawsuit, that could trigger an investigation, but I would caution that if you have received a lawsuit or a threatened lawsuit, that's a time to get IRMA and or an attorney involved moving forward on that. And sometimes you're just required by law. It's a civil rights violation or an anti-discrimination, drugs in the have, again, if you're seeing conduct that is open and obvious and pervasive, and that gives you constructive knowledge, then you should initiate an investigation. Okay. So I'm going to open this up to our panelists to kind of give you an example of what triggered the investigations that they were involved in. And I do need to just make a cautionary statement, is that some of the cases that our member panel are discussing are either pretty fresh, or they may have ongoing ancillary claims or litigation, so they may not be able to delve really deeply into the facts of the case. But what I really want is for them throughout this program is just to share their experiences and their process for investigation. So I am going to open it up. And why don't we start with Eric, if you want to give a rundown of the investigation that you conducted.
Sure, thank you very much. Let me start by just kind of driving home one point that Susan's made already, and something to think about in policy is make sure that you entertain even anonymous complaints from public if they don't want to leave their name. Often our frontline supervisors assume that there's nothing to follow up on if someone just doesn't want to leave their name or doesn't feel comfortable about it. So make sure that your policy kind of addresses that too. That's one thing I found over time that needs to be revisited. In my particular case, it happened that my off-duty deputy chief, driving in his department-issued vehicle, really just going a little bit above and beyond to go check out our new marijuana facility that had opened that day on January 1st of this year, was driving southbound in traffic when he observed in his rearview mirror a vehicle driving extremely erratically. That vehicle ultimately passed him in oncoming traffic. He felt he needed to try to execute a stop on that vehicle and did so. But when the vehicle fled from him and continued to flee, he stopped his attempt to stop that vehicle. Ultimately, the vehicle traveled another half a mile, 3/4 of a mile down the road before T-boning an innocent individual and killing him. That's what started my internal investigation, if you will, in this particular case. It's unique from the perspective that while our internal investigation was running, it was all the accident itself was being investigated by MCAT, Major Crash Assistance Team, who'd come out, and they have a special protocol when it's a police-involved pursuit. So that's what triggered our investigations. Kind of ran parallel, but I think I'll talk about that later on in our presentation as to one of the pitfalls that I recognized as something that I hope all the members to take in consideration. That's how we started off.
Thanks, Eric. Carrie, do you want to give your scenario?
Sure. Good morning, everyone. Our scenario involves a traffic pursuit with motorcycles. On the midnight shift, one of my officers observed a pack of 6 to 7 motorcycles driving on Sheridan Road through town at a high rate of speed. They blew through a red light, and he initiated a pursuit. And shortly after that, a secondary officer assisted him. They chased these motorcycles at quite a distance due to the speed of the motorcycles getting away. Mostly they just saw the taillights as they were chasing him out of town. They chased him for about 2 to 3 miles over a span of about 2 minutes until the motorcycles got on the expressway I-94 and fled south towards Chicago. At the time, the officers were under the impression that the motorcyclists had all gotten away, but 5 hours later during their midnight shift when it got light outside, some joggers discovered a subject unresponsive in a bush line along the path of the pursuit at a point where there's a very dark, sharp turn. So we quickly determined that obviously it was probably involved with our pursuit. So we initiated a couple different investigations. We had an internal investigation because obviously there was a policy violation. Our policy, similar to many, is that we don't pursue traffic violators. We only pursue forcible felonies. Motorcyclist speeding is just traffic, so that was a policy violation. Since it was an accident involving a fatality, we are part of a North Regional Major Crimes Task Force. They also have a crash assistance team, so they came out to investigate the traffic crash. And then since it was a quote-unquote officer-involved death, we also had to initiate a criminal investigation to make sure the officers were following Illinois law. So we had many things going on at one time. So the internal investigation was handled by the department. I had my fire deputy chief conduct that as a unassociated party, so to speak. Like I said, our crash assistance team did the traffic crash investigation. And then we used the homicide branch of the Major Crimes Task Force to conduct the criminal investigation in accordance with the state's attorney to ensure that the officers involved followed Illinois law. So that ours was a little bit complicated because we had 3 parallel investigations going at the same time with 3 different focuses. So it was kind of a lot to manage, but we followed our policies. The Police and Community Relations Improvement Act mandated the outside authority do the criminal investigation. So all those bases were covered for us. So that's the basic synopsis of our incident.
Thanks, Carrie. And Tom, would you like to follow that up?
Yes, I would, but how can I follow up those 2 incidents? My name's Tom Friel. I'm the assistant to the village administrator in the village of Morton Grove. Our example in Morton Grove was recently thrust upon us back in late 2018, early 2019. As I say, it is not as involved as it sounds like our other 2 colleagues online here this morning. But I think it is instructive in a couple of different ways. It begins with a situation in our public works department. We are a village of approximately 24,000 residents. We have a public works department with roughly 37 full-time employees. Ours reared its head over a course of approximately 6 months with an employee that noted the beginning of some inappropriate communications with their frontline supervisor. By the way, this is a situation that is, although the investigation is closed, we are still ongoing with claims. So forgive me if I can't share as much as perhaps our other colleagues here this morning. The comments that were received from the first line supervisor to the complainant were racial in nature, and also may have bled into some private information that was not appropriate to share in the workplace. Nonetheless, these comments occurred among coworkers in full view and hearing shot of coworkers, and actually progressed to a point over, as I said, approximately a 6-month period where the employee sought out from the next level supervisor, I'll call him a second level supervisor, and made a complaint. This is illustrative of, I think Susan referred to it as a trap. It was the classic, I just want you to know about this type of presentation from the complainant to the second level supervisor. That supervisor determined to handle it at his level. Of course, we've all had training per state statute in harassment type investigations. I think this was a bit of a hiccup for us in that although it's admirable that that second level supervisor wanted to take care of the issue, I would also encourage, as Susan's already pointed out, that we need to make sure that when we're faced with these situations, we do follow our in-place policies. So it didn't turn out to be a huge problem, but it started us down a road where we were kind of playing catch up a little bit and put us in a situation we would rather not be in as we continue to discuss this. And I'll only wrap up the introduction by saying this is, as we look back on it, excuse me, is one of those low frequency, high risk type of situations that quite frankly in Morton Grove here, we don't run across that often. So that concept, I think we can develop as we move along through our explanation as the next hour develops. Thank you.
Okay, I do have a question that's come in. What is the criteria to consider using a third party to conduct an investigation versus using an agency personnel, especially when it's not mandated by statute?
We're gonna get into that a little bit later, if they want to, if that questioner would like to wait. We are going to talk about internal versus external investigators a little bit further down in the program.
Okay, thank you.
Okay, so continuing on with what triggers an investigation. Again, if an obligation to investigate exists, it exists. So it doesn't matter if the claim appears to be fabricated, even if the employee, again, we've talked about this, is resistant to the investigation. Sometimes even if the employee is no longer an employee, if that investigation is ongoing, it should be completed. And the overlapping investigation, so you've heard from both Carrie and Eric that they had outside investigations going on as well. So if there's an overlapping investigation, that doesn't mean you don't do your own internal investigation. You're considering, or there's issues with potential policy violations, internal policy violations, you should go ahead and make sure that you are doing that internal investigation. And even if you see that there's some potential for a legal liability, you need to go ahead and do that investigation. If you don't do the investigation, there's a potential that's going to work against you if some type of a lawsuit is filed, where they're going to, make the argument, well, you didn't do the investigation because you were liable, or that the misconduct was, proven, or whatever it is. So you need to, even if it's a potential legal liability, you need to make sure that you're doing that investigation. That completed investigation in that situation can help in a couple of ways. Number one, it may be a good defense. The investigation may come out so that it ends up being a good defense to a lawsuit or a claim in the future. And the other thing it can do is that it can help IRMA and the village and council to make a determination as to whether or not a claim needs to be resolved quicker than normal, or it's a clear showing of liability, then we want to get in there. We want to get that that claim resolved. The other thing I'd like to mention is, even if your the alleged wrongdoer has a claim filed against you or another employee, if there's a valid or credible complaint, you have to do your investigation. You have to follow your policies and procedures. You have to be consistent. So if it's a credible complaint and it's a complaint that you investigated somebody else for 6 months ago or a year ago, you have to do that investigation. If you're not consistent, that's where you run into issues of potential claims of retaliation, or things along those lines. So again, even if it's somebody's got a claim out there already and they're being complained against, you need to do that investigation. I would suggest at that point that you do probably want to get counsel involved to have some guidance and kind of help you through that. Okay, so you want to consider too, when you have the initial complaint, are there some immediate responses that you need to take? Or is there some interim actions that you need to take while the investigation is going on? But they're not a substitution for the investigation. You take an interim action. It doesn't mean that you shouldn't go ahead and do the investigation. You need to do that investigation in full. The interim action may be something just to kind of address the situation. Maybe it's keeping the two employees separated from each other, or there may be maybe a paid administrative leave so that you're not creating any further harm in that situation. You want to make sure that you're preserving your evidence. And here are some other, kind of ideas that you can use, or areas that you can use to try to maybe take that interim action. But again, I encourage you, the interim action isn't the investigation, and that's not going to resolve that issue. So you still need to move forward with that investigation. I want to specifically mention sexual harassment complaints, because those can be very damaging very quickly. So there has to be some immediate action taken in order to protect the potential victim. So again, whether that is a transfer maybe to a different department, or moving their employment location, or a paid administrative leave, something along those lines. But that's something that I would say is very important when you're dealing with harassment claims. You need to make sure that you are making sure that alleged victim is protected. All right, so we have the investigation. We're going to conduct an investigation. So we need to prepare for it. I mean, preparation for an investigation is going to be key. It is going to create the success of the investigation. You have to start out, from the very beginning. So the effective planning is going to be critical to coming down to that final resolution. So here are the things that kind of should start your preparation. These are the kinds of things that you want to consider when you're starting your preparation. And I'm going to open it up again to our panelists so they can kind of share their experiences and how they go about preparing for an investigation. So maybe we'll start with Carrie this time.
Okay, I'll talk about the internal investigation first. For the internal investigation, again, we're just looking at policy violations. So, we want to gather as much data as we can. In this case, we reviewed all the police reports that were prepared about the incident. We reviewed the officers' in-car squad video to see what occurred. And again, as far as the policy violation, it was pretty straightforward. Our policy prohibits chasing traffic violators. That's what the officers did. So the internal investigation was rather straightforward. There wasn't a lot of data to gather. I mean, the video from the squad cars kind of told the tale, as well as the initial reporting. And since it was an internal investigation that likely was going to involve some discipline, I reached out to our HR director and our labor counsel and coordinated with them because we had to put the officers on formal notice that there would be an interrogation. We had to file an affidavit, and then we had to work with the FOP attorneys to conduct the actual interrogation, which again, I didn't conduct it. I had my deputy chief be the lead investigator along with our village attorney, and along with the FOP attorney. They scheduled a formal interrogation. They conducted the formal interrogation, and based on all the information that we had, and that's how we decided how we were going to proceed with any discipline. Regarding the external investigations, the major crash team who came out, obviously we gave them copies of the same things we had, the squad video, all of our reports. We made our officers available for interviews so they can conduct their piece of the investigation. And the same goes with the criminal investigation with the homicide task force. We made our officers available to them. In fact, we had the homicide investigators interview the involved officers before we did our internal interviews with them. That was at the request of the state's attorney. That keeps things clean because any admissions that they might make in the internal investigation can't be used for criminal prosecution anyway, so we wanted to do the criminal component of it first. It also gave us an opportunity to review those statements before we did our interrogation. That's really about it as far as preparing. It's basically just gathering all the information you can, reaching out to the appropriate parties, providing that information to them so they can conduct their investigation, and just making yourself available to answer questions, provide more information. I will say with the external investigations, the key is for you as the agency investigating it to stay out of it. So the two NORTAF investigations were independent of us. Glencoe does have officers on those task forces. They were not part of these investigations. And again, that's mandated by law. So our officers, even though they were assigned to those task forces, did not work on these cases at all. So it was all outside officers, independent, with their own supervision, and we didn't interfere or guide the investigation whatsoever. We just collected their results after they provided everything to the state's attorney to finalize our conclusion. That's all I've got to say about that right now. I think we'll talk about the results of the internal later on in the conversation. Thank you.
Yeah. Okay, Tom, how about you? What do you find important when you're preparing for an investigation?
Tom Friel here again. Our experience with, as you recall, we last left off with a public works frontline supervisor being alleged to have made inappropriate racial as well as a breach of private types of information in front of other crew members. That's where we left off. This ultimately came to the attention of the administrator's office through a written format. Remember, we left off with the complainant going to the second level supervisor saying, I just want you to know about this. Then after a period of time, it developed into a written notification from the individual to the administrator's office. At that point, we did muster our team together, meaning the individual in charge of risk management for the village, which is me, as well as the director of public works, as well as his deputies. It became important to us to first determine and to make sure that we understood that we were following our policy, which makes a differentiation between gathering information to determine if an investigation was necessary versus an investigation itself. And I think Carrie indicated some of the differences may have to do with down the line, the information that you gather and how you can utilize it. So we immediately went into information gathering mode. And we started by looking at the written complaint now and asking all of the individuals, whether they were supervisors or witnesses, to provide written statements regarding the specific dates, times of the allegations that the employee was alleging. So we captured that information, and in some cases it was extremely brief in its written format. In some cases it was somewhat detailed, but we had captured that in the beginning in a written form. When we coalesced that together, we reviewed it, and we were all in unanimous agreement that it did rise again to the level where we were going to have to pull the trigger on an investigation. I'll wrap up this section by saying that, without getting into too much detail, it became apparent based upon the circumstances of the investigation as well as the individuals involved that it became a high priority for us to not give the appearance of any kind of a bias as we move toward the investigation mode of our actions. So that drove our decision-making, along with involving Irma at that point, to look into and favor the choice of going to a third-party investigator to conduct our investigation. So we'll talk more about that as we move along.
And then Eric, how about you? What do you
So-
find important in preparing?
Mine kind of parallels Carrie's really closely, so I won't go into great detail other than to say that, using MCAT as the outside agency, looking at the, the accident in of itself, and then ultimately partnering with the state's attorney for the criminal charges aspect of it, we largely sat back, because my deputy chief was the primary individual involved, made it a little bit more complicated. So I chose to immediately assign an internal commander to monitor the investigation, but really not take any active role at the point until MCAT had largely finalized their outcome on the accident of itself. Once I knew that the state's attorney did not seek any criminal charges against the deputy chief for any of his actions, and ultimately singled it down to this individual, his own actions being the cause for the accident. Then we kind of launched our internal, beneficial from that perspective of being able to use largely a lot of MCAT's work that they had done, and basically finding the in-car videos that existed, the body camera footage that existed, the external camera footage that existed. All of that was given to us, witnesses that were taken, and then we had a launching pad to start our internal investigation to determine if policies had been followed, if anything was violated, what was violated, and to what degree. And so that kind of launched off, I would say, MCAT it takes a little while. So we were probably 30 days into it before we even launched the internal portion of it. But in order to start it off and prep it, I made written notification to the deputy chief that he was to, for all practical purposes, stand down, remove himself completely from the investigation, and that the assigned commander would report directly to me. And so that's kind of how we prepped and prepared for it before we started launching our internal.
Thank you. So clearly there's differences between the employment issue and the kind of the police issue, the police policies or SOPs. So they are a little bit different, and I think they gave you a really good idea of the types of documents that they wanted to look at, that they wanted to investigate. The reports from the outside agencies are going to be very beneficial if we're talking about, obviously you want to make sure that you've reviewed the complaint. If there are, prior investigations or prior claims against a person or other actions, you want to look at those types of situations too. You want to look at those prior documents, make sure that you're getting the full picture. Emails or texts, voicemails, maybe they might all be something that you can use. You can gather that information, as Tom was talking about, gathering the information, to make that determination as to whether or not to move forward. So, it's important for you to maybe take some time and think about what are the things that you want to see, what are the things that you want to look at to help make those decisions.
Susan,
I just want to, I'm sorry, go ahead.
we do have a question.
Okay.
If a criminal investigation did result in charges, is it best to wait and see how the prosecution plays out, or should the internal investigation be done concurrently?
That's a good question.
And then he does have another one to piggyback on that. And what from the criminal case outside investigators is the agency entitled to for internal investigation purposes? Like, would the agency get discovery or investigative files?
The agency that is doing the internal.
Yes.
I do not believe that they would be entitled to. That's another really good question. I don't know whether or not they would be entitled to get the criminal file as a part of their investigation. I mean, certainly, I think it is something they would want to look at if they had the ability to get it. I think the other like investigation reports that we're talking about with MCAT or those other ones, obviously those would be a part of all of that as well. Whether or not to have the internal investigation while the criminal case is going on, honestly, I'm not sure about that. You don't want to delay it for too long, but you do need to have all of the information before you can make some determination on, what the result is or whether or not there was a violation. So I think in some respects with regards to that, you may want to have some guidance from counsel as to how to proceed. I mean, when we're talking about police officers or firefighters, they do have some rights, which we're going to talk about in a little bit, with regards to interrogations and admissibility of their statements and things like that. So I would want to. I wouldn't want it to go out for a year, an internal investigation. But I think there should be some guidance with an attorney, I would say.
Okay, thank you.
All right, so this was the other question that we had is selecting an investigator. So investigator is going to be an important part of, obviously one of the most important parts of an investigation. So the question is, do you select an internal or an external investigator? And I think that, our panelists have given some indication as to kind of their thoughts on why they chose a particular investigator. And I think a lot of it is going to come down to, number one, if you have a internal investigator that's well trained and they can be objective and impartial, they're going to know the policies and procedures. They need to be, have a high level of integrity, credibility. That employees have to respect them. And sometimes it's, who do you use? The one drawback that you have when we're talking about an internal investigator, and I'm going to open this up in a bit for the panelists, is the potential for bias. Is it going to look like your internal investigator? Maybe they're entwined with the management, so they are maybe more biased. They're also going to potentially have, an ongoing working relationship with these employees, and there may be a concern that that they are going to be compromised with that future relationship. And so then we're talking about external. So these are kind of the areas that you want to talk about when you are determining whether or not to use external or external. And I think that the extent of the, and again, I'm going to open this up in a minute, the extent of the violation will guide whether or not, you want to use an external. The protection for the, the police officers and the requirements under, the law that they are to be subject to, an interrogation and how that all has to work. So I think that all lends itself to, using an external investigator in those types of situations. So here's, the areas that you can go. These are the areas of the people that you could go to have that investigation. I do have this like one little word of caution when we're talking about using corporate counsel or labor counsel, is just, the perception maybe that they might be biased as well, since they're getting paid by, the municipality. So, and not saying that that's the case, but it may be a perception out there. So just something to keep in mind when you're making those determinations about which investigator to use. So I am going to open it up. I know some of our panelists already talked about it a little bit, but I'm going to open it up to see if they have any additional thoughts on why they selected the investigators that they selected. And maybe Eric, do you have any additional thoughts?
No, because we're part of MCAT, that was just the natural person, and this was a pursuit involving a death. That's where we went to. I will say we kind of struggled, or we ultimately, as this investigation continued, we struggled with MCAT's actual findings, and there is a conflict from the perspective of how the terminology that was utilized in the report of their finding, and how that kind of exposed us and will expose us legally down the road. The conflict is we're part of MCAT. We're a paying entity and a contributing entity to the ultimate investigative entity that's doing the investigation on our guy. So again, you have some of that bias, or that bias is certainly going to be naturally raised. But we don't really have there's really not a whole lot of other choices that are logical ones that move forward. I think had our case been more complicated, or appeared at face value to be that the officer was more at fault, then we might have considered other options, but ultimately went with MCAT.
Thanks. Carrie, I know you mentioned that you went to counsel with regards to your investigation, and I know you mentioned it was partially because of the rights of the officer when they're being interrogated. I didn't know if you wanted to expand on that at all.
Yeah, well, the reason we did that was we knew there was going to have to be a formal interrogation with FOP representation for the officers. So we reached out to Labor Counsel early to involve her so she can kind of manage that process for us. And again, like I mentioned earlier, since I'm the ultimate person who decides any discipline for policy violations, that's why I had a deputy chief actually run the investigation in coordination with the Labor Counsel. And again, the external investigations in my case were driven by the law. I had no choice. We would have done that anyway, because it's still the cleanest, most transparent way to do things like that. And I agree with Eric, the fact that we're members of the task force, there could be some, cries of bias in the future. But, in our case, we were lucky. All the results came in, the investigation was completed, the state's attorney rendered their verdicts, and the 2-year time has elapsed and we weren't sued for it. So I think that's a tribute to all of our processes being above board, appropriate, and very clear and transparent. And I think, luckily, things were in our favor because of the actions of the outside investigators and the way they conducted their investigation.
I mean, I agree. I think that that's one of the benefits. And when you get into, the formal internal investigations and you do the investigation that you need to do, I think that it does help, down the line, as I said, even before, even if there's a potential for legal liability, we're creating, maybe we're creating a defense, or maybe we're creating at least a situation where we can look at it and say, yeah, if the claim is filed here, we need to deal with that directly. So,
Right. For general policy violations, obviously we do internal investigations, with a supervisor in the department running those. But since this one had a bigger reach, so to speak, we thought we'd involve counsel early.
Yeah.
Susan, we do have a question. With officer-involved shootings in Cook County, it's not unusual to not receive the Illinois State Police Public Integrity Unit report until 12 to 18 months after the incident.
Correct.
Our belief has been that the IA can be initiated but cannot be completed without that report. And what are your thoughts on that?
In our case, I consulted with the Cook County State's Attorney's unit rather early, and the Professional Standards Unit was the agency involved, and they did recommend that we use the state police. We did not use the state police. I reached out to them. They would not take the case because our MCAT unit had started the scene investigation. So that's why we used our homicide unit. Frankly, my experience with the state police unit is exactly that. It takes them 12 to 18 months to do their investigation. And in our case, my general thought was, yes, our officers committed a policy violation. I determined that and we'll talk about this later, but I determined their actions didn't cause the death. So I didn't want to have them in limbo and on administrative leave for that long. So we sped things up a little bit. It still took 5 months. The North Taft investigation took 2 or 3 months to do. They gave it to the state's attorney. They took 6 weeks to review it before they rendered their decision that the officers didn't do anything improper. So the state police integrity unit, it does take a long time. We could have used them. We didn't, and actually it made things a little bit quicker for us.
Thank you.
Okay, and Tom, I'm going to throw it back to you with regards to your determination, your choice on the investigator. You had it all internal, correct?
Susan, no, we didn't. And again, listening to our two colleagues, Eric and Carrie, certainly their situation's a lot different than the one that I've framed so far for Morton Grove. However, some of the similarities in making the decisions on whether to go internal or external, we ended up electing for an external investigator. And the 3 points that I thought I would hit that were important to us in that decision was, number one, because of the nature of the allegations, which is, as you will recall, involved allegations of inappropriate racial type of comments from a supervisor, as well as allegation of inappropriate release of private type of information that normally would be considered employee protected. We wanted to, primary in our thoughts were maintain the privacy of the complainant, so that, how things go with perhaps internal investigations. We did get some written statements from named witnesses in the allegations and involved supervisors, but we didn't want it to go any further than that and get churned through the rumor mill, so to speak. So that was primary to us. Secondarily, I think some of the parallels with some of the police investigations is, for us, I mentioned this before, this is a low frequency, high risk situation for us. And from that, our history would tell us the low frequency aspect, but the high risk, because of the low frequency, we really didn't know where our highest risks were. here with this and how it would develop. There was a lot of details to unpack with some of the privacy information. There were some allegations of releasing information on social media among the supervisor and the involved employee. So we really needed somebody to be able to weed through some of that cloudiness for us. And lastly, I mentioned it before, some of the circumstances that I can't actually elaborate on, but some of those were important enough to us to ensure that there was absolutely, to the extent we could control, no potential to come back and whipsaw on us about a bias or a slanted type of investigation, no matter what the outcome would have been. So those were the three primary things in our kind of HR related situation here.
Okay, all right. Thanks. And you know, I agree, and I think I kind of mentioned it up front. It's a little bit more difficult in some of these situations when you do have an internal investigator handling it. Some of these more, like I think you said, you know, high risk, high exposure cases are probably better left to an external, and you don't run into that bias thing. And I just wanted to make clear as well is that I chose the panelists so we have examples from kind of both sides. So we have the employment example as well as, you know, the police example. So I wanted to kind of give a rounded view of how you know, members can be making these decisions in the different types of areas that they're going to run into. So I did want to make that clear that the choice to have police internal investigations and employment internal investigations was a conscious decision on my part. All right, so once we have an investigator, we've decided how to go forward with our investigator. Now we want to talk about who we want to interview. Who are the people that are going to give us the best information to make these decisions on the investigation. So you may, you know, consider, obviously you want to talk to the complainant and the alleged perpetrator, but there may be witnesses that, you know, that saw something or heard something. Do you want to, you know, look at coworkers, maybe even vendors or service providers that may have witnessed an incident, but also just, you know, you need to keep an open mind throughout your investigation, throughout the investigation. Because you may learn new people who might have witnessed something, or maybe you learn some new information that could lead to somebody else that you may want to interview. So it's really important to, well, you need to kind of maybe put a plan in place as to who you want to interview, but don't close it off that there might be others out there that would be important to interview as well. So how do you want to document the investigation? There's you know, you can use all of these options or some of them, but the most important thing to remember when we're talking about that is don't destroy any documents, evidence that you've gathered during the investigation, because it may be a part of an investigation down the line. You know, you may have an issue if you destroy all the notes and then we end up in some type of litigation. There may be a, you know, question of whether or not there's what's called a spoliation of evidence claim, which means the documents were destroyed, and then that will be the perpetrator. It will be like kind of viewed in favor of the perpetrator that you destroyed the documents, and the reason that they don't have the documents anymore is because maybe you didn't have the right you know, the right information to take to take the action that you took. So it's very important not to destroy your documents that you've made during the investigation. You know, when you're documenting the investigation, if you're taking notes or you're recording, you want to make sure that it's all focused on the facts. You want to keep the documentation neutral. You want to make sure that you're not including your beliefs or your assumptions, or any of your conclusions. The investigator has to be different than the decision maker. So the decision maker is the one that's going to take what the investigator does, and they're going to make that determination based upon those notes or the documentation of the file. That's why it needs to be very neutral. It needs to be just the facts, not secondhand information, not gossip, not rumor. You need to document all of that so your decision maker has a good record to make that decision, that ultimate decision. All right, so we've got all of our documents, we've got our investigator. So now we're going to start conducting interviews. So my kind of first recommendation is before you start an interview, you probably want to prepare an outline of questions to be used. So to be more consistent, you have a more consistent line of questioning. You minimize the risk of, potential claims by interviewees. They asked me something different, or they, phrased it in such a way that, was unfair to me. They didn't ask the same question of, the other party. So I think just kind of a standard set of questions to start with is a good idea. But again, keep an open mind, because questions, answers to questions may lead to other questions. So you can, go off of the standard questions that you've asked to follow up on information. And I would also consider using a separate set of questions for the alleged wrongdoer. So you're ensuring that you're getting a response to each of the allegations that may be made against the wrongdoer. So here's the kind of a roadmap, what we want to get out of interviews. Okay, so I think one of the most important parts is to make sure that what you're getting is personal knowledge. What you're getting is the personal observation. So it's not a rumor, it's not secondhand information, it's not, oh, I heard so-and-so said this, or I heard, that she said that, or she did this. You want to make sure that the information that you're getting from the interviews is firsthand information. That'll, make it easier to make your decision. Asking open-ended questions. So you don't want to be leading the interviewee to their answers. You want to make sure that it's not just a yes or no answer. So questions like, what conduct did you observe? Or what did you hear? Those types of questions, kind of leave it open for the person that you're interviewing to maybe expand on an answer and give you a little bit more information than you might if it's just a yes or no answers. Always ask a witness if they are aware of any other witnesses that should be interviewed, any other documents that should be viewed. Always ask, I would say always ask at the end of an interview, is that everything? And allow them to maybe, provide you additional information. Maybe it's something that didn't come up in your questions, but something that they have on their mind. So I always, say you should ask that last question. Is that everything? So these are the items that I would say you want to stress to the interviewees before you question them, so that they know, again, that they're being protected, that they're not going to be retaliated against. You want to make sure that, they know what the purpose of the investigation is. You want them, to be cooperative. And if you, have to refer to your policies on cooperation in the workplace, then that is something that you should do. You want to make sure that they are encouraged to report retaliation if they are being subject to retaliation for their participation. And again, advise them that they shouldn't really discuss their interview or what they know about the situation with others. The other thing is don't promise absolute confidentiality. Okay, so you need to keep it as confidential as possible, but there may be some individuals who have a need to know. And if they have a need to know, then you're going to have to give them that information. But you keep it from the people who don't have the need to know what the result of or what those interviews encompass. So don't ever promise that it will be kept absolutely confidential. Okay, I'm going to take this a little bit further first. I'm going to change a sec. So I wanted to go back to the panel to discuss what their involvement in the interview process was, and if they were a part of that process, if they learned anything new, or if they were the decision maker, what did they learn through the transcripts of the interview. So just kind of their perspective on what the interview process basically gives or provides. So why don't we start with Tom?
Very good. We when we last picked up, we had decided to go to an external investigator. We chose to consult with our with our labor counsel and go with a recommended attorney that they had given to us. We engaged that attorney, and one of the first things we did do that we found very handy was we convened with the attorney as well as the upper level supervisors that were not directly involved in the allegations, but had history, not only personal history, but work history of both parties, the alleged victim as well as the alleged wrongdoer, so that they could provide some perspective to this external attorney, the external investigator, to formulate a pathway or the questions that she wanted to get answered in the interviews. We then talked about kind of an order of the interviewers, or I should say interviewees, based upon the allegations. One thing that was decided early on that we would interview the alleged wrongdoer last. That kind of folded into some of the strategy for how the questions and who was involved in the first few interviews. We found it handy, right or wrong, to interview from the written statements of some of the witnesses. We interviewed what we thought to be some of the for lack of a better term, lower level witnesses, those witnesses that really didn't see much, weren't sure what they heard, et cetera, et cetera. More of the material witnesses were saved more toward the end. And as I said, the alleged wrongdoer was last. We did, and I'm sorry I skipped over it, but we did interview the complainant first to make sure that we had a good understanding of the allegations as we had already received them in a written format. So that was valuable to us. As far as my personal involvement in the interviews, I was a fly on the wall. I was not involved directly in the interview itself, talking with either the witnesses or the alleged wrongdoer. But I think that came in handy as we debriefed after each individual was interviewed. And that kind of spawned, I think, as Susan indicated, some discussion and we talked about actions that we may take as a result of the information we were learning as we went. So I know I'm speaking in vagaries here, but it was it was important and wound up being important to us in the end, that the order that we talked about, as well as the discussions after each interview occurred, were important to us and actually worked out in the end.
Thanks. And Carrie, I know you mentioned that you were the decision maker. So I'd like to, kind of get a feel from you. Is what did you look at? Did you have like transcript of the interview that you used in making your decision? And was there anything new that you learned in reviewing that information?
In my case, again, the policy violation itself was rather straightforward. The only people we interviewed were the two officers involved. And again, I was not in the room. I was not part of the interview process, but I will say during the preparations, we did sit down with our labor counsel. Like Susan mentioned, we came up with a script of questions we wanted the officers asked that was consistent, so they were both asked the same things. The goal of the interview was just to get the officers to describe what happened, to kind of give us their thought process of what they did and why they did it. And then we also wanted them to acknowledge and talk about our pursuit policy and how they think this case either was guided by the pursuit policy or not, just so we can make sure that they fully understood what our policy is and have them explain why they violated, if they even consciously violated during the incident. Pursuits are very high energy, the adrenaline's flowing, it's very, very quick. So, sometimes officers make mistakes and they just don't apply policies properly. So we just wanted to get a foundation of that as part of the interview. Yes, I was the decision maker after the interviews were done. Obviously, previous to that, I was privy to all the information. I write all the police reports. I watched the squad video. And as I said, the squad video really told the tale here. It showed, the pursuit as it occurred. It also showed to me that the motorcycles were so far ahead that my officers had no idea that this motorcyclist had crashed. Due to the darkness, due to the distance, due to the speeds, they thought that when the group got on the highway and left town that the group was intact. It wasn't until hours later. So I knew going into it that yes, our officers violated the policy, but I did not think going into the interview that their actions caused the death of the motorcycle rider. That was caused by his erratic driving, his high speeds, and other factors that came out during the criminal investigation. But after the interviews were done, I sat down with our labor attorney and our HR person and my deputy chief who were in the room. None of the answers that the officers gave conflicted anything. Their statements during the interview were very consistent with all the reporting and what the video showed. So the interview didn't really add any new information. It solidified some information for me. And after that, I was able to determine what discipline we would be imposing.
Okay, thanks. And Eric, what about you? Did you learn anything new through the interview process? Were you the decision maker?
So yes, this was the decision maker on policy violation, but this is a part of the presentation where I'm going to give you a lesson learned.
Okay.
And you heard Carrie just talk about how intense and stressful a pursuit can actually be. And I don't know that many of us look at this as on a parallel to an officer-involved shooting. My mistake is I made my deputy chief available to MCAT for their criminal interview within hours of this actual incident taking place. Shame on me, huge mistake. And the reason it's a mistake is because he was obviously going through some stress that came out in some of his answers. His answers weren't wrong, they weren't deceptive, but what they were they were off, and they were off by distance-wise. So example, he felt he turned his lights off at a particular point. Well, when you go back and look at video, that's actually 1,000 feet, different from what his statement was. I think going back, I might treat these types of situations much like an officer-involved shooting. Make sure that there's time involved for that officer to decompress before any statements are made. largely that was my mistake because, again, much like Carrie, this was really at face value. I didn't feel, or nor did I think that that the officer, the deputy chief, had done anything wrong. He had done his job. He'd done what he was supposed to, what he was expected of, and so I didn't anticipate anything coming to the contrary. But remember that MCAT's focus is criminal in nature. They do not, and nor should they, have any consideration as to the civil liability that becomes evident after the fact. And so from that perspective, learning lesson for me, I would have not made him available immediately afterwards. I would have largely followed our use of force policy and given decompression time before any interviews were done so as to avoid any of the misconceptions in his statements. With that said, something that you pointed out, Susan, that's very important is we reconducted every interview internally with every person that the outside entity had interviewed. And again, we found that people's perceptions changed as time moved on. Not that they didn't see what they didn't see at the beginning, but largely that some of their depths were changed and their time perceptions were changed. And so that was really critical and important to digging into this from a civil aspect. I mean, I think that's all that I would bring up on this particular topic.
Okay, thank you. All right, so when we are talking about interviewing, oops, I need to go backwards. Doing interviews or investigations, there are some legal considerations that have to be kept in mind. And a couple of those, there's they're called Garrity rights or Loudermill rights. Oops, wrong way. And these are in essence, these are due process rights for your employees. So under Garrity, a public employee can't be compelled to incriminate themselves. And under Loudermill, the public employee is required to have due process before being dismissed from their job. These rights stem from the Fifth Amendment and are extended to the state through the 14th Amendment. And it's basically their rights not to incriminate each other and the right to due process. So these rights are really geared just towards public employees because the public employee works for the government. Then when they're being questioned or when they're being investigated, they're being investigated by the government. So these rights become important to them from that perspective. So you have to, under Garrity, you have a duty to advise the employee of his Garrity rights. I know some members may ask an employee before they're interviewed to sign off on their Garrity rights so that they understand that they may have criminal or administrative liability for statements that they make. It also advises them that they can remain silent. That may implicate them in a crime. And so it's something that you should consider working with your labor counsel on. You may have just help you create a standard kind of form for these Garrity rights that you could give to employees when you are questioning them, investigating them. So a compelled statement. So what is a compelled statement? It's really, I think in Illinois, it's fairly narrow and it's the threat of termination. If you are threatening somebody to be terminated if they don't answer your questions, and you're in violation of these Garrity rights. So you need to be very mindful of that. The employees do have the right to remain silent and not incriminate themselves. And under Loudermill, they have the right to have some type of a pre-termination hearing. They should have the ability to present their side of the story before there's a final determination on termination. So it has to be some type of a hearing. It doesn't have to be anything really formal or elaborate, but you do need to give them the opportunity to express their side of the story, or have them not argue, but any type of information that you have that they disagree with, you give them the opportunity to provide that information. And then there are also specific rights for the police and fire. There's statutory rights for those for police and fire when you are subjecting them to an interrogation. These are the protections by law that they are entitled to. You have to, give them written notice. It has to be a sworn complaint. You need to make sure that there's reasonable that the investigations or interrogations are a reasonable time, that they get some rest. They need to be, while they're on duty. They need to be advised that they have the right to counsel or union representation, and that kind of falls within the Weingarten rights also that we'll mention in a little bit. So this is when they're subject to an interrogation, and Carrie talked about it, bringing in the outside counsel, bringing in labor counsel to assist with making sure that all of these rights, that the officer was protected through all of these rights. It's only when it's an interrogation. If it's an informal inquiry, then they don't need to go through these specific rights or these specific provisions. So if you're talking about to mediate a citizen complaint, or you want to discuss facts, maybe even just to determine whether or not there needs to be a formal investigation. Those don't necessarily need to go through all of these legal protections, but if you're getting to the point where you are interrogating, then you do need to comply with these rights. You need to give them warnings that they have the obligation to respond. They have the obligation to be truthful. They have to be advised that their omissions may be used as evidence. And any information that is learned during an improper interrogation can't be used in subsequent disciplinary proceedings. So I'm sure most of our police departments understand all of this already. I would ask Carrie or Eric if they have anything that they want to add, or any other perspective on this that they wanted to share.
Yeah, this is Carrie. My only perspective is that, part of our policies include a formal investigation notification form, which was drawn up by our labor attorneys, covering all these topics that you're talking about. So my suggestion is, I'm sure most departments have it, most villages probably have it, but if you have that as part of your policy, you have the form that exists, it just saves you a lot of time of putting everything together before you conduct an interrogation with one of your personnel.
Thank you. All right, so we also have unionized employees have rights under the Weingarten case. And so if they reasonably believe that they might be subject to discipline, they do have the right to have union representation. They have to make a request for that representation. And if they make that request, you as the employer, you either have to grant that request and delay questioning, or you can deny the request and then you have to end that interview immediately. And you need to give the employee the choice of either interviewing without representation or ending the interview. So they also provide it's an unfair labor practice if you deny the request for union representation and you continue to ask questions. So the employee at that point, they have the right to refuse to answer questions, and they cannot be disciplined for refusing to answer those questions. So if there's no reasonable expectation of discipline, then there's no right to representation. And so these are kind of examples of meetings or questioning about that wouldn't necessarily be a reasonable expectation that there's going to be discipline. So one of these types of situations they may not be entitled to have union representation as a part of those scenarios. Okay, so we've completed our investigation, and now we're going to execute the results. Okay, so this kind of comes in 3 parts. You want to document the factual findings, you reach the conclusion, and then you implement the corrective action. We talked a little bit earlier about factual findings. You want to make sure you're verifying that you're getting verified facts, make sure you're getting the whole story. So we got questions of credibility. A lot of these situations may come to questions of credibility, a he said, she said type of situation. So you want to make sure, and I've said this a couple of times, you want to make sure that you're getting firsthand knowledge. It's not gossip. You may want to take a witness's motives, into consideration, just to judge to their credibility, not to whether what they're saying may or may not be true. But you want to make sure that you've taken that into consideration when you're determining, their credibility. Make sure if you're the investigator, then your findings need to be neutral. Right? Leave the conclusions to the decision maker. So you want to make sure your findings are plain and clear. You want to make sure you're not committing to any type of a remedy. And you want to document the finding in the context of the violation of the policy. So the policy says, 20 absences in a month is a violation of your, personnel policy. So if you're doing that investigation, it's coming down to that. You want to make sure that you're saying, here's the policy provision, and here are the findings, and this is why it's found to be a violation of the policy. So you make sure that when you are documenting it, you are doing it in the context of the policy. Okay. So this is important. The decision maker should never be the investigator. The decision maker needs to take a look at facts outside of the, what the investigator has maybe been exposed to, and that. So decision maker needs to look at the facts as they see them through the investigation to make their decisions on whether or not there is a policy violation. They need to review, the applicable policies, review the facts and the findings, assess the credibility of the evidence. And it's kind of more not in the time like where the investigator is, but you're looking at it from a more overview, a more, maybe I want to say unbiased position when you're looking at all of this evidence, trying to make that decision as to whether or not there's a policy violation. Then you have to make that, determination what the response, if there's going to have to be legal conclusions or legal findings, then you're going to need to have a guidance of an attorney with regards to those types of findings. So when you're taking corrective action, you should take it immediately, make it appropriate, again, consistent with the rule violation. If it's a tardiness issue, you may not want to, give them a week suspension for, being tardy once or twice. I think, when you're talking about, some of the Carrie and Eric, when it's a little bit more of a serious violation, obviously you need to take that into consideration when you're talking about whether or not discipline is going to be issued. If there is the, set up a pre-deprivation meeting as is necessary. We talked about that under Loudermill. So if you have, you're making that discipline, you're going to terminate, you should be setting up a meeting with that employee to make sure that they are getting their due process rights. And so not everything has to be discipline when we're talking about taking corrective actions. You know, sometimes training may correct the problem, maybe counseling may correct the problem. So not everything is discipline when it comes to a corrective action. There may be other ways maybe to address that. And I think I talked in the beginning, and maybe an employee just, you know, got misinformation or just misunderstood something, and those, you know, the corrective measure could be as simple as, you know, giving them the proper policy, or, you know, correcting that misinformation that they may have. All right, okay. When we're talking about harassment investigations, those are kind of special. They're a little bit, I don't want to say higher level, but you have to take actions that are necessary to end the harassment. You need to make sure that the victim is being protected, or the alleged victim is being protected. And you need to make sure that that misconduct isn't going to recur. So, you know, is it a, you know, separating the employees, maybe the alleged wrongdoer, you know, is on administrative leave, paid administrative leave while you are investigating the claim. You know, maybe you can put them in, you know, separate offices, or transfer somebody to a different location. But you just need to keep in mind, you need to, you know, make sure again that your victim is being protected from while the investigation is ongoing. All right, so here is the end. These are the results. So I'm going to turn it back over to the panel to kind of think. You probably have an idea of what happened in most of these investigations we were kind of talking about, but I thought, you know, if they have any additional information, what their results were, and how it worked out, that would be great. And we start with Eric.
Real quick, so criminally, obviously, the officer was found to be not in violation of any criminal law, nor was the accident attributed to any of his actions. That was from the state's attorney, made that determination. As far as making this quick and decisive, that wasn't an option in this case, because we were dependent upon outside entity to finish their investigation really before you can end your internal investigation. So that took 6, 7, 8 months for that to be done. Ultimately, I found that the deputy chief was within policy, that he didn't violate the pursuit policy. However, there were some ancillary policies that needed to be reviewed with him as to the expectation of preparation for duty when you're in a department issued vehicle and you are in town, whether you're off duty or on duty, et cetera. So those things were covered pretty low level. At the end of the day, you know, making sure that you maintain the communication with that outside entity, that you're walking that fine line between what you're entitled to, what you're not entitled to, and keeping in mind that the outside entity has a specific mission, and that your mission is both to make the determination of criminal liability, but also civil liability, and make sure that you're trying to run as parallel as possible to, you know, avoid any of those crossovers in the future. I did have our labor attorney and our corporate counsel take a look at the documents that I've prepared in the closure of the policy violation, so that language was crafted in such a way that it didn't contradict anything from the criminal investigation, and likewise. So that was our outcome. Thanks.
Thanks, Eric. Carrie?
Our outcomes were, we kind of took a different track than Eric did. Our goal initially was to complete the internal investigation as quickly as possible. Our internal investigation was completed within 5 days of the incident. Our officers were placed on 3 days administrative leave in the interim. So when they were interrogated, they were technically on duty. They were on paid administrative leave. And again, that was a conscious decision between ourselves, the labor attorney, and our village manager, you know, being confident that our officer didn't violate the law. So even while the criminal investigation was ongoing, I imposed discipline against the officers. The initiating officer received a 2-day suspension. The secondary officer who assisted late in the game was given a written warning. Both officers were provided with critical incident debriefing because their actions were involved in an incident resulting in the death of a civilian. And we also did a policy review on our pursuit policy with all of our personnel. Even though we do that periodically throughout the year, this incident sparked us to do that again, just to make sure everybody was on the same page with our policy on pursuits. Regarding the criminal investigation, like I said earlier, that took 5 months. And again, that was part of our decision-making of doing our administrative process quicker. I didn't want to have these officers on paid administrative leave for 5 months, waiting the outcome of a criminal investigation when we were very, very confident that they did not violate any Illinois laws. So we had, a quick conclusion for the internal and a 5-month conclusion for the external. And in the meantime, I think that took some of the sting out of waiting. I think it, showed some good faith on the part of the village and believing in our officers and backing them up and supporting them, even though they they were involved in a policy violation. They didn't violate Illinois law in our estimation. And that was proven to be true after 5 months in the state's attorney review of the case. So we had kind of a prolonged overall investigation, but at least the officers had some finality a little quicker, which is what our goal was.
And finally, Tom.
Yes, outcome of our our investigation really was boiled down by the external investigator in a written report, boiled down to 3 specific areas that the external investigator opined on whether or not the allegations were founded or unfounded. First one was relative to remarks made by the supervisor to the alleged victim regarding racial type of orientation. That was found to be founded. Recall that this was also over the course of roughly 6 months, variable types of incidences, comments, but bear in mind that all of them were witnessed by coworkers. I shouldn't say all, but the majority of them were witnessed and corroborated by coworkers. The second was as the alleged wrongdoer was the supervisor of the alleged victim. There was a duty to protect certain private privileged information from release. That was the second finding that was founded by the external investigator. Again, in the release of that information in a public venue was found to be exacerbating to the situation. Thirdly, we didn't touch on this, but the alleged victim had also alleged that interaction with the frontline supervisor from a standpoint of performance review, specifically regarding actions taken on the street, street maintenance, things of that nature. He had received a poor performance review, and the alleged victim alleged that this was retaliation for other types of back and forth arguments that had occurred over that time. So that was determined to be unfounded by the external investigator. But to conclude, all of these findings went to the village administrator, who was the ultimate decision maker per our policy on harassment. And it was determined, due to the exacerbating circumstances, the public nature of some of these comments, that the wrongdoer actually was assessed a 5-day suspension. Along lines of what Susan was indicating, we did formulate this in what we call internally a notice of contemplated discipline to this particular individual, a written statement that provided the charges and the level of discipline that was contemplated by the administrator was provided to the individual, and he was provided an opportunity to sit down and respond to that contemplated discipline. So we felt that covered things like Loudermill and et cetera from there. Ultimately, the individual did not choose to fight the contemplated discipline and ended up taking the 5-day suspension. But beyond that, I think it's important also to note, because this was a harassment type of situation, because all of our employees had gone through the requisite anti-harassment training, actually within the previous, I believe in this case, it was the previous 12 months, again, exacerbated the situation. However, following up on that, we did send all of the involved supervisors, the complainant, as well as the wrongdoer back for refresher training, and where appropriate, enhanced supervisor training also to pick up on some of the, I don't know if I'd call them missteps, but to try to increase our competencies and proficiencies in the future with recognizing and following our policies on this in the future.
Okay, well, thanks. And I just want to, just a couple of follow-up comments, and both Carrie and Tom mentioned them, is that after an investigation takes place, it probably is a good time to look at your policies, review your policies with your employees, so you're going over it again, just to kind of, again, give a refresher. And actually, Tom, I believe it was me who came out and did an enhanced session for your supervisors to talk about handling those types of claims. So I think that these types of investigations can end up being kind of maybe or you should make them a learning experience, a review and a review of your policies and a review of your procedures with your employees that may come out of some of these types of investigations. And with that, I will open it up to any questions.
Okay, Susan, we currently do not have any questions in the queue right now, but I do want to make everyone aware that this is, again, the second session for our summit. Next week, we are going to have 2 topics, one with workman's comp investigations and another one with zoning. We did send out information yesterday regarding those registrations. So if those topics are something you're interested in, please click on the link and register. And as you exit this webinar today, you will have just a little evaluation to complete. We would appreciate everybody completing those. That gives us a gauge on what you would like to hear in the future from IRMA on any topics or any situation that you're interested in hearing about. And as I'm seeing that we're not having any more questions for this time, Susan, if you want to go to the next slide real quick. And if you do have any additional questions or comments, you can always reach Susan at her email or her office line. She's always available. If you have any questions that you'd like to talk to our member panel about, we can get you their information as well. And as always, our webinars will be posted on our website for you to view at a later date. If you have anyone from your organization that would like to see this or look at the PowerPoint, that will be posted within the next 48 hours. So with that, I'd like to thank everybody for joining us today. As you exit again, please complete that survey, and everyone have a great day. Thank you.
And thank you to our panelists as well.
Thank you, everyone.